All right, good afternoon, guys. Welcome. I'm really glad that you're here. You're going to learn a lot. We do have a lot to cover, and we're going to have a good Q&A session as well. So real quickly about me, my name is Anthony Bandiero. This is what I do for a living. I teach search and seizure. I'm also an expert witness. I am an attorney and also a former police officer. I worked in Las Vegas for the troopers and also the Elko Police Department. So I don't want to spend too much time on my bio. If you want to know more about me, go to bluetogold.com and you can just go on to about. I do want to plug a few things. One is I have two books. One is the Search and Seizure Survival Guide. A lot of you probably have seen that book and purchased it. It is the most popular criminal law book in America. It's been that way for a while. It's what cops like about it. It's very down to earth, straight to the point, and it talks about over 160 different legal topics that you can run into as a police officer. Everything from this topics that we're talking about today, but also motor vehicle searches and exigent circumstances, Miranda. And it gives you best practice. I also just came out with a new book called The Bulletproof Report Writing. That book is really trying to fill a niche for the report writing needs out there. My experience is that most police report writing classes are English 101 classes. And, you know, I like to say we're not losing cases because of misplaced comma. We're losing cases and potentially even lawsuits. We're losing lawsuits because officers are not articulating what they need. And oftentimes what's kind of sad about it in my, is that when I talk to these officers who, lose big cases or get sued and they tell me what happened out there, in my head, I'm like, man, you're righteous. You had all the things that you needed to really win your case, but they weren't in the report, or they weren't articulated, or the prosecutor missed them and so forth. So that's one thing to kind of keep in mind, is that oftentimes officers, 99% of the time, maybe 98, but are doing the right thing, but they may not be articulating correctly. And that book is going to help you. I put this up before we started to connect. Please, now that, with all these travel restrictions, it's really brought home how important, social media is going to be for this company. Most of our activities for the last several years have been live training, and I'll admit to you that I've not been on my A game with social media. But now it's this whole emergency and crisis has reminded me just how important it is that social media is going to play in getting officers trained. And this is a good example that this has been on my list for months to do webinars and online training. So there's some resources for you. All right. The other thing before I get into, I want to just plug that we have full day classes every week online now, right? And so last week we're supposed to be in Wichita and also Pennsylvania. So we moved those classes online. I think, and maybe some of my students are in this class from last week. If you want to, maybe do a shout out to all the attendees if you enjoyed that class, but it went way better than most people expected. They think, 8 hours in front of a screen. It's not like that. It can be boring if you don't have the right instructor, but I think, I put a lot of effort to make it very interactive and so forth. So please consider signing up for either one or all 3 days of my search and seizure training next week and then the week after and so forth. Disclaimers. Just remember that we're going to talk about a lot of law here. It seems to me that almost every state is represented in this webinar. Certainly you have different culture, and your prosecutors and your jury pool are going to play a part in your success in the courtroom. So laws and agency SOPs may be more restrictive. Also, if you have any doubts about the legality of your actions, push up the chain, right? Get somebody else's input if you think that you may have a search and seizure issue or a legal issue that you're not sure about, especially if that time is not a factor. And finally, this course is legal education, not legal advice. If you need legal advice or you need an expert witness, certainly call me. Go to bluetogold.com. But otherwise, this is just my opinion about where the law is in 2020. Here is an overview of what we're going to talk about. We're going to talk about curtilage. We're going to talk about hot pursuit, imminent destruction of evidence, preventing escape, entering homes to prevent a danger to you or others. And we're going to talk about plain view if we have time. We'll see how it goes. All right, curtilage. So curtilage is, in my experience, one of those things that's hard to teach. A lot of it, I think that just some courts just don't understand, really what curtilage is and where it starts and where it ends. It certainly depends on the layout of your home. Oftentimes in my classes, students will say, Anthony, I had this call and, was I on the person's curtilage? And they'll try to describe the house, but, honestly, for me, I want them to pull up that Google map. And then I'm looking at the house and I'm like, all right, here's where I think curtilage is. Curtilage is based off of 4 factors. We'll ignore the color codes for now, but, curtilage looks at things like how close are you to the home itself? What's the use of the area? Is this barbecues and lawn furniture, pools and jacuzzis, or is it like farming or, just open space? We also look at, is there a fence around the house, right? Or the area that you want curtilage? And finally, has somebody done something to keep prying eyes out, right? So it's hard for somebody to have curtilage when anybody walking by the house can see, in the front yard and on the side and so forth, and maybe even the back. But those are all factors. It doesn't mean that just because you can see into the backyard that it's not curtilage. It just means that that factor works against it. I'll tell you that most of the time, backyards are very protected under the Fourth Amendment. But where the real questions come up is not so much where it is, but what can you do on curtilage, right? And so in order to explain that and teach officers, I've come up with a color code system. And I think you're going to find it extremely helpful. And really, the courts do not call it this, do not call it that, hey, you're on a red zone or a yellow zone and so forth. But when you look at what they're deciding, it's this. It's that they are conceptually articulating the same thing through these color codes. So first of all, I'm going to show you places on homes and property that are, your quintessential curtilage. By the way, curtilage is French for curtilage. It stands for courtyard. And just to kind of make another kind of remark on this, you cannot use the word property instead of curtilage, because somebody can own 100 acres and that 100 acres will almost never in a million years be all curtilage, because curtilage is treated like the home itself. So I don't, it's not my favorite word, in my classes, because it's kind of, it's just one of those words. We would never use the word curtilage, outside of law enforcement or the legal system. If you buy a new house and I come over, I'm not going to tell you, man, that's some badass curtilage you just bought here. That's just, we don't talk like that. I would say, that's a nice house or a nice property, but still, that's why it is a legal definition that we need. So we have red areas. I'm going to describe, I'm going to give you examples. We have areas that are red. Red are areas that are your quintessential curtilage, your backyards, your carports. And in order to be there, you have to have a justification. Yellow areas. Yellow areas are those areas of a home that are also curtilage, right? But you're allowed to be there during a call for service or a knock and talk. And then finally, we have green. Green are those areas that are open fields and are offered zero protection under the Fourth Amendment or your state constitution. So the first premise that we have to start with is that curtilage is treated like the home itself. And so that's how the Supreme Court views this. And, so that's a pretty big deal. I mean, the U.S. Supreme Court is telling you that when you're in somebody's backyard, for example, most of the time, that's as if you're inside their kitchen. Now, in the real world, that is not exactly true. I have plenty of examples of cops being in the backyard when they could not have been in the kitchen. But it does start the proper conversation of where are we starting with this? How should we view curtilage and view it like the home itself? Meaning, if you're on it, you better have a good reason. All right. So generally speaking, you may be on curtilage for one of two reasons. One, you're there for a knock and talk, right? That just makes sense. At 2 o'clock in the afternoon, you walk up and knock on a door. You can certainly, under most circumstances, be on that property. If it's not a knock and talk, and you're going to be in the backyard, at 2 o'clock in the morning, in the front patio area, porch, you need exigent circumstances. Something has to be going on where you don't have time to wait. Now we're going to go through this, but that's kind of where we start our proposition. Our premise is that if you're going to be on curtilage, you have to have a reason. It's not a just because reason. So here is the foundational doctrine about, knock and talks. The public, including police, have implied consent to approach the front door, knock promptly, wait briefly to be received, and if unanswered, leave. That is where we start. That is pretty restrictive. And why I say this, because, if cops go to a front door for a knock and talk and then start snooping around, that is going to be a problem, right? I mean, we're going to look at where they're snooping. I mean, if they're on open fields, then we don't have a problem. But if they're, hanging out and going to side gates and, looking into windows, and you find plain view evidence, you are going to have a very tough time in court. Explain to the judge why that truly was plain view. All right, when it comes to curtilage, right, and these color codes, I like to think of them as the Terminator movie. Remember Terminator 1, and he's scanning everything, and here he's looking for clothes because he's butt naked. But what I like to think is, look, when I go to a home and, we're looking at curtilage, we want to scan, we want to evaluate where do we think the red areas are, yellow and green, and so forth. So if you look at this house, right, where the sidewalk and the street, what color would that be under my color-coded system? Somebody throw it out. Green all day. Awesome. It's green all day. You can be there day and night in your police vehicle, in your undercover vehicle, looking at that place. You can also use binoculars if you're not being intrusive. If you're not being intrusive. What intrusive normally means with binos and any kind of technology is, are the binoculars seeing something that you could see with the naked eye? If you can see it through the window, we're talking about the window here. We're not talking about the outside of the home. We're talking about the inside of the home. You use binoculars to look inside that kitchen window, living room, and so forth. If you use binoculars, the court may ask you, officer, were you able to see that contraband? Let's say there's a brick of cocaine on the kitchen table. Were you able to see that contraband with the naked eye? If the answer is no, but you only saw it because of binoculars, a good attorney is going to get that suppressed. A good attorney is going to get that suppressed. That violates somebody's privacy in the home. Remember, the Fourth Amendment applies to police, not the public. Certainly, a member of the public could be a peep and Tom and use binoculars and cameras and so forth, but that might be a violation of the law, but that's not the violation of the Fourth Amendment, but that could be. What color would the driveway be, including in the front door, under my color-coded system? Awesome. That's right. And by the way, I have a very good friend on. I just saw his name, a guy named Chad from Fort Worth, Texas. One of the best cops that I've ever met out there, and it's good to see you, Chad. I can't wait to come back to Texas and start teaching live classes again. All right. And then finally, we have red. Red are those areas that you cannot be on without a reason. And so this would be an example of red areas. As I give an example, if you are knocking on the front door for a knock and talk to follow up on an investigation, let's say you have intel that the person is, has a stolen car, and your partner walks over to the right-hand side and looks in the backyard and sees the stolen car, is that plain view? That's right. It's not plain view. That's right. It's not plain view. Now, I'm going to tell you that cops have been doing stuff like that for generations, right? They've been doing it for generations, and it's gone over the heads of prosecutors, defense attorneys, and judges, but not anymore because of the body-worn camera. It's not that the cops were playing games, by the way. It wasn't like the cops really thought they violated the Constitution. Many cops do not think that that is that's being intrusive if you just walk over to the gate, but it is. And what happens, they'll put in the report, I saw the car in plain view, and then when the defense attorney pulls up the body cam, it shows the cop on that side of the house. And then the next legal question is, well, officer, why were you there? And the officer's like, well, we're doing a knock and talk. I don't think I need a reason to be there. I mean, it's, whatever. And that's just not the rule. So now, yellow versus red. Now, at 2 o'clock in the morning, right? At 2 o'clock in the morning, that yellow area may be red now. And that's why, it's underneath the yellow is red, but it only turns yellow if you have if you're doing a knock and talk. We're talking about knock and talks here. It's only, so somebody asked a very good question. Do you need PC or reasonable suspicion to be on red? You need something, but you also need exigency, right? Some kind of exigency needs to be there. So for example, if you have, let's say you have probable cause to arrest, you're welcome, to arrest the occupant for, it can be a serious crime, by the way, but let's say you have for strong arm robbery, and you have probable cause to not only arrest him, but he is in the backyard hanging out. Can you just go back there without any other articulation and arrest him? What do you guys think? Right. You cannot be back there. So I'm not saying, right. And there's a little pause, by the way, with the questions. And I want to try to make this interactive. I'm not saying there may not be a reason, but with those facts that I gave you, even though it was a serious crime, that alone does not get you in the backyard. That's why you need some kind of, exigency there. Now, before we move on, I talk about the example of where, let's say that you're doing a knock and talk and there's a party in the backyard and they're not answering the front door. Okay, so far so good. And then you move over to that area on the left where that gate is, and you yell over the gate to the occupants to try to come to the door. Now, that would normally be red because why are you there, right? It's not where the public seems to be invited. But with those facts, do you think you can justify being over there to try to make contact with the homeowner? I agree. So that's great. So what's happened here is you turn that red into yellow. And why is because you can justify to the court why you believe uninvited guests would be there. Now, I'm not even going to ask it because I already know the answer. Many people on this webinar are not going to go in that backyard to do a knock and talk. You know that you have no right to be back there. But if you're there for a domestic violence or even a loud party call and they're not shutting down the music at 2 o'clock in the morning, many cops feel confident they can justify going back there, especially the DV. And I'm right with you. But let's move on. So let's look at this case. The officers stopped people in front of a house for an open container violation. So they're drinking open containers in the street. Now, Alexander, who turns into our defendant, he sees the cops. Now, he's on his property. He's also drinking an open container at the time, but it's not a violation because he's on private property. He then grabs a bag and grabs the bag, and he goes to the back of his house, then comes back out with no bag. So here is the house, okay? And Alexander and his friends, you know, he was on the steps. And again, he grabbed the bag and he went back towards the back. So what I want to do, I'm sorry, before I show that, what then happened was the officers are like, man, that was super sketchy, right? There must be something in that bag. By the way, they found drugs in, there was a car too in front that they were drinking and so forth. They did find drugs in plain view. So now they have a drug investigation. Alexander just did what he did with the bag. So now they're thinking, probably rightfully, right, that Alexander had evidence in that bag that he just hid. The officer then went to the back of the house, right, and found the bag and opened it, and there was a like a Mac-10 and another Ruger pistol, and, you know, serial numbers obliterated. You know, you get the story. He's also a felon. So my question for you is, you know, did the police violate curtilage with those facts that I gave you? I see a yes. Yes, probably, yep. So here's why, okay? Here's why. First of all, let's look at our color codes, right? You know, what color is the sidewalk in the street? I mean, you guys, that's an easy one, right? It's green all day long, right? So, but here is how I would articulate the rest of the property. The area on the stoop, you know, it is those areas where you can make contact with the guest, you know. So generally speaking, it's going to be yellow. He was there initially. The area right in front of the window is going to be red. But do you see how I have color-coded the back where that Nissan, what is that, a Maxima? Where that Maxima is, a cop should not be back there without exigency. And so somebody has a question. So 1 second. Let me move my mouse over here. All right. So what if you're on a sidewalk, green, yep, and you see a stolen car from the sidewalk? Without going onto the curtilage, red, would that be suppressed in court if you were to act on that? So, well, that's a great question, and we certainly have no problem seeing what we see. We're going to talk about plain view if we have time, right? Plain view is nothing more than right to be, right to see. So if you're on green, everything open to view, open to hearing, open to smell is game on. We can use it in a warrant, probable cause, whatever. But with those facts, if the car is on red, so for example, this picture is a great example. Let's say that you look at that Maxima and it doesn't have a front plate, I don't think, but if it did have a front plate and you ran it and that car is stolen, could you go up there and recover the car? No. Nope. I hate to say it, but everybody that said yes is going to lose the car. And here's why. You have to get a search. You have to have what's called CREW. Okay, this is something that I came up with to help cops. CREW is consent, a recognized exception, or a warrant. You do not have implied consent to go grab the stolen car. It's on his property. You do not have a warrant, and you also do not have a recognized exception from a court. A common recognized exception would be the motor vehicle exception, right? But the problem is, where is the vehicle? If the vehicle is on red, you have no authority to go onto a red area to grab the car, even though it's stolen. That is a U.S. Supreme Court case called Collins versus Virginia that came out in 2018, I believe, or 2019. And so the answer is no. So if you go on there and and the court agrees that that is a red area, you are going to lose the car. So, you know, when the officer found the guns back there, he was on red. And if you're on red, you need some form of exigency, right? Your safety is in jeopardy. Somebody is getting beat up. You know, a person's about to flee. You know, a lawful arrest, etc. You have to have exigency. You cannot have just probable cause, and that's what happened here. And by the way, even if first of all, I think we all can agree that maybe the officer should not have even allowed Alexander to just grab a bag while the drugs are found. I mean, the drugs were actually in plain view pretty quickly. I think we all agree that he's involved in this investigation, right? So why are we allowing Alexander to even grab a bag and take off from that immediate area anyway? You guys see what I'm saying? But the problem here is that once the officers allowed it to happen and he dumped that bag and then came back out, the exigency was over because he's not near the bag anymore. So we don't even have a Terry frisk type of analysis and so forth. So there is no way to get the bag back in here under a warrantless exception unless we had consent, which they didn't even ask for, but they probably would not have even gotten. All right, let's talk about this case. This is another kind of interesting case. So what happened was a guy named David Bowling was driving drunk from a bar to home at 6:30 at night. And when he, on his way home, he left the roadway, ran over a pedestrian and killed him, and then made it home. David parks his truck behind this house. This is where that white car is. This is this is not a it's a Google map picture, not one from the case. So the house looks a little different. But what happened was David parks the truck behind the house. The next morning, a neighbor sees him pull the truck into his garage. Now, you may be able to see my mouse here, but right next, these garage doors, they are garage doors. They look like they've been converted to living quarters. But at the time of this case, they did not have windows. And so David pulls the truck into the garage, but he leaves his door open about a foot off the top of the ground so that a dog can kind of come in and out. A neighbor called Crime Stoppers because she said, look, I just saw in the news, 3 days ago, that somebody got killed by hit and run. My neighbor has not driven his car for 3 days and now is parking in the garage. It just seems suspicious. So they decided to do a knock and talk. That's our next move. We don't have probable cause based off of this. Well, they knock on the door and he does not answer. They then, the cop gets on his hands and knees, right? And while he's on his driveway and looks under the garage door and sees the vehicle in plain view. It has blood on it and damage consistent with an auto ped. My question for you is that a lawful observation? You guys are nailing it. You guys are nailing it. Man, that is not a lawful observation. So here is how I would look at that house, okay? The problem here is they were snooping. You are not allowed to snoop around somebody's house during a knock and talk. It offends a person's privacy interest. And because the cop was on yellow, right? He had a right to be there. It's not a problem for where he is standing. The problem is what he did. And getting on the hands and knees to look under somebody's property, in somebody's property and so forth, is intrusive and therefore is a search under the Fourth Amendment. It is not plain view. Now, I'll make a joke that if the cop needed to tie his shoe and tied his shoe and then happened to see the vehicle in plain view, that would have been upheld as long as it was legitimate, that it wasn't just a ruse. But that evidence was suppressed. The vehicle was suppressed in that case, and it got remanded back to the lower court. And most likely, I have no hard proof because I can't find the follow-up, but most likely David was released from custody and the case was dropped. If they articulated, so first of all, just to remind everybody, if you can please, you guys some great questions. If you can please try to answer to all panelists, which is me, and all attendees, because a lot of people want to see your questions and your answers. And please use the chat box, not the Q&A. So if they articulated that the purpose of the knock and talk was exigency, hold on, let me just make sure. I got to move something on my big screen here. Was a welfare check. Okay, yeah. See, I got this Q&A thing up here. So, yeah, so nobody can see this question besides me. So that's one reason to let everybody view this. But it's a great question. If they articulated that the purpose of the knock and talk was for a welfare check, right? Could they have looked, is that exigency? Well, the answer would have been maybe if the neighbor did not see him driving the car the next day into the garage. So that's the problem, is that we know that he went home that night, he parked his car behind the house, and the next morning he moved his truck into the garage and has not driven it in 3 days. With those facts, there's no legitimate reason to go into his house and snoop around to check on his welfare, because we don't have facts that he actually is in need of community caretaking. So the answer would be no. Now, another officer asked the question, considering this, this is about the Alexander case, right? With that shed. Considering they found narcotics nearby in the background of Alexander, is there enough reason to believe there may be evidence in the bag that he's trying to destroy? Here's the problem. I think that they have probable cause, right? Based off the totality of the circumstances, do we believe now that Alexander moved evidence from the scene? I think the answer is yes. I think a judge would give you a warrant. But the problem here is we have no exigency, because Alexander came back to the front of the house. And now that shed was approximately 68 feet from the detention, right? And where's the exigency there? Where's the exigency there? All right. How would that, so Chad asked, how would that have changed if the neighbor saw blood and the damage? Basically what the officer said he saw and reported back to the officers, good for a warrant. I think we're good for a warrant, but not for exigency with those facts that I gave, because we knew that Dave was walking and talking the next day. So the answer is, I think we get a warrant. And that's what's actually sad about this case, is that they still lost the vehicle. Now, a lot of cops will say inevitable discovery. Well, if you're going to throw out inevitable discovery, you need to prove that you would have gotten a warrant. All right, let's push on through. There's a few things. It's kind of a peep and Tom rule. If you look like a peep and Tom, then that is not allowed during knock and talks. So areas not considered curtilage or open fields. This is very easy. Here's a case where Tuckahoe Turf Farms, the cops had a report that people were, shooting guns and violating various wildlife laws. So they went to go look for these people. They were on their own property, though, right? They own the farm. And the court said that was a violation. I'm sorry, the court said that this is open fields. And just because you own it doesn't mean that there's a privacy interest here. So there are 4 exigent circumstances that get you on people's property to get you onto red areas: hot pursuit, imminent destruction of evidence, prevent escape, and danger to the officers. Let's go through some examples. So hot pursuit. You may chase a fleeing suspect into their home for any arrestable offense if the chase is immediate and continuous. The key here is you have to start from the outside of the home, right? Let me share with you a case. that the cops had probable cause that a guy named Peyton was wanted for murder, okay? The murder occurred 2 days prior. They go to his house. They knock on the door. They believe that he is home at the time. He does not answer. They make an entry. Well, while there, they see the murder weapon in plain view. And are we good? The answer is no. Just because with probable cause alone will not get you into people's homes, you have to articulate some kind of exigency, right? And I want to talk about this case. A husband and wife get into a fight. Wife goes to her parents. Husband goes to his parents. It is important in this case that the husband proved later that he lived there every so often, like stayed the night at his parents' house. The deputy knocks on the door. The husband comes out. They're talking. The husband is being very non-cooperative, uncooperative. Finally just walks back into the house and says, you know, screw you. I do not want to talk to you. The deputy then radios to his partner who is talking to the wife. And the partner says, hey, hook him up. We have probable cause that he battered her. He then walks into the house to arrest him for the domestic. Are we good? That's correct. No, we're not good. We're not, you guys are nailing it. We're not good. The problem here, okay, and it was an easy fix, but the problem here is that the chase occurred when the guy was already in the home. You know, and somebody said a Stiegel warrant, by the way, which is you need a warrant for a third party's residence to go arrest somebody. If you have an arrest warrant for their residence, then we're fine. But my point is the chase did not happen outside of the front door. It happened while the guy was already in the front door. That was the problem. If you look at constitutionally, you know, how I would view this property if I put on my Terminator vision is like this. There was an easy fix for it. I'll give you a few seconds. What would have been the easy fix for this cop to do with this husband to have prevented this issue from occurring in the first place? Well, he did step outside though. Detain him. There it is, Nate. Detain. That's right. Detain him. Once you get him out, tell him that, hey, you know, just so you know, you're being detained for this investigation. Once he's detained, he cannot go back into the house. Therefore, you have obstruction. So that's how I would have handled this. Well, look, it could happen to the best of us. But in the future, if you have any situations where you're not sure that you have probable cause yet, and you know, and you're to prevent him from going back inside, tell him just so you know you are being detained. Then he can't go back in. Now, if you lose sight of the suspect, right, during a hot pursuit, you're chasing the guy, the general rule here is that, look, if you lost sight of him for a few minutes or so, it's not a big deal if you find him again and then pick up the hot pursuit. It happens frequently with vehicle chases, foot chases. You lose the guy for a little bit, and then you start chasing him again, and he goes into a house and so forth. Generally speaking, these cases, you're pushing it constitutionally after 15 minutes of losing the person. But if you lose him a little bit and then have probable cause that he went into a house under hot pursuit, you can still chase him into that house. So let's watch this video real quick. Let me kick off my video 1 second. All right. What do you guys think? Does that look like legit hot pursuit, even though they may have lost him, the dirt bike or the ATV, I mean, all day? That's a great example of hot pursuit. Even though you lose him for a little bit of period of time, once you find him, even if he's inside of a home, you can do what they did there, including a forced entry if it's for, we want serious crimes here, but certainly we have a serious crime. We have, you know, evading and so forth. So we're good. Now let's talk about destruction of evidence. I hope you guys are enjoying this, by the way. Some of my people that have never taken a class from me, I hope you're enjoying the content I'm giving you. I'm trying to give you a lot in a little bit of time. So, all right. Destruction of evidence. Thank you. So here is an issue that kind of comes up, okay? If you have probable cause that a person has evidence in their house that can be destroyed and you're going to get a warrant, you cannot automatically go in there without another articulation that the evidence will likely be destroyed, or you have probable cause and so forth. You have to have both probable cause for the evidence and then also a separate articulation that the evidence will be suppressed. All right. Yeah. No. Thanks, Tom. I appreciate it. I mean, I usually am very animated in person. I don't know if you've taken my class before, but I'm trying my best here. We got to keep the company going, right? So here is the 4 rules. If you want to take a picture of this or whatever, if you have the book, it'll be in there. But if you have clear probable cause, the evidence is inside the home. Clear probable cause just means, abundance of probable cause. We don't like thin cases when going into a house with a warrant. You're going to get a search warrant. You have to go get this, you have to have the intent to go get the search warrant. You can't have that intent formalized after the entry. Let's say you thought there was personal use methamphetamine, and then you're like, we're not going to get a warrant. Well, that's not quite true. There are some cases that don't necessarily hold that up, but you should be, getting the warrant. You have reason to believe someone's in the home, and especially for the warrant for the search for more evidence. Let's just be clear on that. And then you have to have a PC that the evidence will be destroyed in the meantime. That's the main thing that you want to put in your report. That why did you believe that if you waited to go get a warrant, that by the time you came back, the evidence would be destroyed? The officers were investigating a burning car on someone's property. So that's a fun night, right? That's a fun night. It's probably every weekend in some of these places, right? While they were searching the property for the occupants or who owned the car, they smelled the distinct odor of methamphetamine coming from a trailer, right? And then as they got closer, they heard people bolting out the back door. They then went in to secure the trailer for a warrant. That's all day, every day exigency. The key with those cases too is the courts, if it's true that you say that the persons were running, hiding, that type of thing. Mere noise is not enough for exigency, just so you know. Mere noise, people moving around is not enough. They want to see something about the being secretive or taking off running or glass breaking or toilet bowls flushing. They want something specific. Now, police had reasonable suspicion that a guy who was on the sidewalk in front of this house just sold drugs. They then went up to the door to do a knock and talk. A lady answered the door, saw the cops, and immediately shut the door on the cop's face. The cops then went in and saw evidence in plain view. Are we good? Man, you guys are nailing it. That's correct. Now, do we know what time it is? I mean, do we know, as cops and so forth, that, that just having a reasonable suspicion that a drug transaction just occurred, plus them slamming the door in their face, we know what's up. The problem here is that courts rarely let you use that piece of information against them. The homeowner shutting or slamming the door on your face is not, unfortunately, I mean, I can see it both ways, but it cannot be used as part of the probable cause, because people have an inherent right to not consent and to also not accept your knock and talk, to just see that you're a cop and be like, no. Just like a person, answering the door to a vacuum salesman or a security system salesman does not have to be polite to the person and say, hey, I don't want you here. They can just slam the door on the person. And now if that person hangs around, they're trespassing. So that was not the missing ingredient. That's an interesting case that brings that home. Let's talk about to prevent escape. If you have probable cause that the suspect either has plans to escape, how do you know this? Because his, you overhear him saying it, or his co-conspirator says it, whatever, right? Or while knocking on the door, you see or hear him, the person escaping, then you can make a warrantless entry to prevent that escape. So here is a U.S. Supreme Court case that kind of reminds us, though, that you still have to articulate that exigency, right? Just because the person may want to escape does not mean it's automatic exigency. So what happened here was that Olson was the getaway driver for a armed robbery at a gas station turned murder. Now the murder happened like 3 days ago. There's 3 suspects involved. They get the 2 shooters, they get them in custody. They find the murder weapon. They then track down Olson, again, the getaway driver, to this house. And this is actually the picture of the house. Now, the roommates he has 2 roommates, and the police talk to the roommates over the phone. And they're like, hey, is Olson there? And they hear a male, the roommates are female, and they hear a male in the background telling him, hey, tell him I'm not here. Well, now they have reason to believe he's there. They then surrounded the house with, I think, about 8 officers and told Olson to come out, and he did not come out. They then made a forced entry to take him in custody, and they found other evidence in plain view. And the question is was that true exigency? I think it's a very tough case. I see, my officers are already saying no. I personally find that it's on the line. I think we're close, but the key here is that there is no evidence that I gave you that anybody was in danger. If you thought that the roommates would be potential hostages, and you have reason to believe that for some reason, then I think you're good. If you don't have enough officers, I agree on the line. Yep. If you do not have enough officers to surround the premises, then you may have to go in, right? But as I told you, they had like 8 cops there, and the court was not convinced that if he actually did go out the back door, that he would have been not detained or arrested. Also, remember, the murder weapon was already found. There's no reason that he was armed or dangerous. So it's on the line. If you had something else to add to it, they probably would have gotten it, but the evidence was suppressed. Well, here's the deal. So they had 8 cops there. So Jeffrey asked, if they left to go get a warrant, he would leave. Absolutely. But they had enough cops to sit on it and to go get the warrant at the same time. But if you're working for an agency, right? I go to a lot of places which are rural, and I teach a lot of rural officers. I tell them, constantly that you get to do more stuff than LAPD, than Fort Worth Police, in Tarrant County and so forth, because they have a lot of officers. I make a joke. I can prove it. Every time I got into a fight in Vegas, I had cops coming out of the woodwork to get involved in that fight, right? But when I needed a cop to help me with the tow, it was crickets on the radio. So those cops are out there with big agencies. You just got to find them. So in here, if they only had like a couple officers or whatever, then I think you're going to make the entry. And I told you, this is what they knew. I already told you that. Now, I want to talk about this case, okay? Sometimes it's hard to estimate how long these webinars will go. So, I talked about like having some Q&A afterwards. I am going to stick around and answer questions, but I have it scheduled until 1:30. I hope that, we can kind of push Q&A back because I want to get through some of this material, and hopefully you'll stick with me as long as you guys can. Utah, by the way, has the best warrant system that I've seen in the country. They can do them from their cars, and it's just incredible. All right, let's continue. Here is a case out of Ohio, another place I love teaching at, by the way. And what happened here was a tipster called Crime Stoppers and said that the occupants of this house were growing marijuana. And so what happened was they sent a narcotics task force to go do a knock and talk. Well, per their county policy, they did a surround of that. They surrounded the house for officer safety. So I want you to first picture, you know, the area that they're standing on, what color would that be? In the front door, you know? Right. And what about the backyard? Right. So here's how it looks constitutionally for the, okay? All right. You see what's going on there? They are in this guy's backyard. As I told you before, if you are going to be in the backyard, you have to have some exigency, right? Some urgency, some emergency, something that is like, man, something's pressing. And when they went, now you can kind of see the marijuana plant, the cop in the back saw the marijuana grow operation, quote, in plain view. And when they go to suppression hearing, the officer was asked on the stand, why did you believe that you actually were allowed to even be in the backyard? And in other words, to have plain view. And the cop said, because my policy said I can do it. Are policies allowed to exceed the authority under the U.S. Constitution? Absolutely not. In fact, even a law that you have on the books cannot trump the Fourth Amendment, right? It has to be all within compliance with the Fourth Amendment. So this policy was unconstitutional on its face. And not only was the evidence suppressed, but the cops were sued. And the cops weren't really in any trouble because they didn't do it on their own. They did it because of the policy. So the cops were actually released at the end of the day, they're released. But the county was on the hook for money. Now, do you think that officers around the country, and maybe I was one of them, have been in people's backyard for just generic officer safety purposes during calls for, you know, during knock and talks and so forth? Absolutely. Hell yeah. I think cops do it almost, you know, probably somebody does it every single hour in the country. But the reason I'm saying, the reason I'm bringing this up is because if you are going to do it, you can't just say, I do it because of officer safety. Officer safety, furtive movements, nervousness, all those are just dead. Those are not statements we can just throw out into the court and expect them to stick. We need facts and circumstances to believe that our safety is at risk. Do you think if they got intel that this guy is violent history on Leo's, he, you know, has weapons and he's, you know, maybe he's on paper for, you know, some kind of armed robbery, do you think that maybe would have gotten us in the backyard for officer safety purposes? I don't have your case, but I think the answer is yes. Give that to the court, not a general, that's the way I do business type of thing. That is not going to work. And by the way, you know, the court said it was clearly established that the cops violated this guy's rights. So just remember that. That's a good case for that. All right, we have a Q&A question. I'm not sure if you can see these. I don't think you can. So if you see a vehicle in someone's driveway and can see a license plate from the street and confirm the plate is stolen, why can I not recover the vehicle? Hold on. Okay. I'd like some of you actually. Okay. So actually somebody else typed too and it kind of threw me off a little bit. So why can I not recover the vehicle? The case law you provide, Collinsville, Virginia, does not match because the officer went onto the property to further investigate to include lift of the tarp. If you can view from the plate from the street, why would you need a warrant? I disagree with that interpretation of Collinsville, Virginia. I think it's very clear in that case that the officers had probable cause before lifting up the tarp. The bike, you could see the chrome rims under the tarp. The bike had an elongated frame. Collins took a picture of the bike in front of his house, which is where they were at. In fact, the picture he had on his Facebook page was where the bike was found. So I don't think that the case turned on the issue of actually searching the bike. It turned on the fact of recovering something with probable cause. And the problem here is that if the area is red and if the area is treated like the home itself, right? Well, if you have a PC that I have stolen property in my house, can you just come into my house and go recover that property? I have no privacy interest in my stolen property. But the problem here is you have to do another level of invasion of my rights in order to get it. That's the problem with the car being on red. And by the way, Colin said that even if there's a debate about the tarp, and again, I don't read the case that way, but even if there's a debate about the tarp being the actual issue in that case, the U.S. Supreme Court said that the motor vehicle exception, having probable cause for a vehicle, does not allow you to go onto curtilage to recover the vehicle. And then, so we're in the same boat. Great question, though. And it comes up a lot, by the way. It comes up a lot. For the case of the stolen car in the driveway, if I'm standing in the street and I can see the license plate with no assistance from binoculars or anything else, and the plate comes back stolen, the vehicle meets the description of the return. It's the same type of question, right? And by the way, you can use binoculars on cars outside of the rule about binoculars has to do with windows. It has to do with windows, looking into windows and so forth. It does not necessarily mean that you cannot use binoculars to see stuff that is also, outside of the house. So that law is not the same as inside the house. So hopefully that helps. Hopefully that helps for the guys that gave me those questions. All right. Let's talk about danger to officers. And by the way, I'm gonna use this as an opportunity to plug. In my traffic stops class, I go over Collins v. Virginia in detail, including pictures of the house, pictures of the bike, what exactly happened, and we walk through it step by step. So please, one of the reasons I'm doing these free webinars is to try to get you guys to consider taking online classes from me until this blows over and I can get back out and do live training, but I still need to keep training. So please consider that, including next week. We have a class starting next week on Tuesday. It is now talk about, for people in danger. It is clear that police may enter a dwelling without a warrant to render emergency aid and assistance to a person they reasonably believe to be in distress or in need of that assistance. A housekeeping employee disappeared during her shift. Her street clothes and lunch were found in the 6th floor break room. After a thorough search of the hotel, every room was searched on the 6th floor, including rooms that were occupied by tenants. She was found murdered inside the defendant's closet. We are good. We are good. So we have an exigency here, right? We have somebody that is missing, probably somebody on the 6th floor and so forth, and now we have exigency to get into the room, and so the evidence would not be suppressed. Another student asked, how do you find your online training? Great question. It's at bluetogold.com. And if you go to the right corner, you'll see course calendar. And if you click there, you'll see all the upcoming training and so forth. So please consider signing up. All right. Let's watch this video. All right. That is a great video to show you what's going on with those. Why do you get to go into people's homes during a domestic investigation? By the way, there is no recognized exception that simply says anytime you're investigating a domestic, you get to go into the home. The underlying reason why you get to go in the home is to protect somebody or to restore the peace. Community caretaking is part of it, but community caretaking is under attack. Community caretaking has, including California, I got a lot of people from California watching. Their court the Supreme Court of California just said that under community caretaking, it's not just as a best practice and to kind of, you have a reason to believe something. It has to be some kind of emergency, like a legit emergency. A lot of other courts are going with that type of language. Community caretaking is more common outside of the home. So even though you can throw in community caretaking, I actually think your first line of articulation is exigency. As long as you believe that a spouse needs your assistance to not get hurt and to prevent another breach of the peace, that's why you get into DVs. Now, to throw something else out there, how many times have you been on DV calls and after, 15 minutes, you're like, man, there is no DV that occurred here. And then the husband is like, I want you out of my house. You should consider what's going on there legally. If at some point you believe that no crime has been committed and nobody is in danger, if you believe that, and then you have a tenant, a co-occupant who has authority over the premises telling you to leave, constitutionally, you should probably leave, unless you can point to something else to keep you there. I hope that makes sense. All right. Let's talk about protective sweeps. So there are 3 protective sweeps under the Fourth Amendment. Now, these protective sweeps are when you're already in the house. So, oh, by the way, that video, the other point about that video was the knives were in plain view. Knives, guns, drugs, whatever, right? That's another great example, because what the fight is going to be over is that actually it was in that video, the female got arrested for domestic, and the knives were used, part of the evidence. And that's going to obviously increase the charge, right, to aggravated and so forth. So that's a good example of how those knives are going to come in, because as long as the police officers can articulate that somebody in the home is in danger, in fact, maybe somebody's dead, with all that evidence of violence, that is going to be upheld all day long. That's a great video of not only the entry, but the plain view evidence. Now that we're in there, let's say that you find the person and you hook them up. Where can you search, right? Well, the first thing, this is called the Chimel Rule. The first thing is that the person, you can search their lunge area. Where can you search? Anywhere that a weapon could be, evidence, if evidence is part of the crime, means of escape. Now, cops ask me, hey, how long does that, lunge search last? It's not very clear under the cases. Many courts give you some slack, but here's my general guidelines to keep you out of suppression hearings. That lunge area search lasts until the point where the suspect is in custody with handcuffs, they are double locked, and he is being cooperative. I want to repeat that. I think my best practice is that lunge area search ends when they're handcuffed, double locked, and they're being cooperative. If those 3 things are in play, I do not think constitutionally there's a very good justification to keep searching around in lunge areas. The second area that you can search is adjacent areas. If you arrest the husband for DV in his bedroom, and there's a walk-in closet and a bathroom attached, you can go in there and look around for people in people-sized places. Not for weapons, unless they're in plain view, but people in people-sized places. So if you go into the bathroom, you can certainly look behind the shower curtain. You can, look behind the door and so forth, but you cannot open up the medicine cabinet. You cannot open up a drawer. If you did and you found evidence in plain view, that is going to be suppressed. Finally, you can only look throughout the home if you have an additional reason to believe that somebody is in the home that could pose a danger to you. You do not get the entire house just because you arrested somebody in the home. You have to give the court something to make you believe that you could be in danger. Now, I'm going to share a little. I've been studying this for 20 years. I've read tens of thousands of cases, and after so many cases, you start getting intuition about what the courts are looking for. And I'm going to tell you, when it comes to this, not much. Not much. Your safety, is a legitimate concern while you're in people's homes. You're on their turf. There could be guns everywhere, hidden and so forth. There could be people hiding out. Just got to give them something. You hear noises. There are 5 cars out in front in the driveway and so forth, but yet only one person is inside the house. There's probably somebody else in that house. And the fact that they're not visible and not out and about makes you believe that they're hiding, and hiding could be ambush, and it's, and so forth. So your safety is at risk. So just give the court something. But the first two, lunge area and adjacent areas, you get on the house. The third one you have to justify. Let's watch this video real quick. Again, I hope you guys are enjoying this. I know I am. I love teaching search and seizure, so hopefully you guys are getting something out of this. All right. All right. So let's talk about that video. This video, I love this video. There's a lot of teaching points in this video. So let me just kind of, go through it and just tell you some of the things that I'm seeing, and you let me know if you guys agree. Now, first of all, we have a room full of teenagers. They're all drunk, high, so the first legal question that's important for us is, can they enter the home? I'm sorry, well, the motel. Do they have some form of exigency? Yeah, we're on the same page. Remember, community caretaking is good, but again, a lot of courts want to see not just that you want to make sure that people are okay. They want to see exigency. But I think we can articulate that, the guy throwing up, there's no adult supervision. They're in a motel room. It's not like it's a house party where, it's a little bit different environment. Hotel rooms have real world limitations. There's no adult present. There's, the smell of marijuana. I think we're going to get in there to make sure, because in other words, would you be derelict in your duty if you just left? Of course you would. I mean, you probably, if the public found out about that, they're not going to be very happy with how you handle this. So that's one way to look at it, is that if you did not do something, would you almost be derelict in your duty? And the answer would be yes. What about searching under the mattress? Are we good? See what's going on here? Now we have a fight. You see, we have cops saying yes. We have cops saying no. This one is going to be tough, guys. It's going to be tough. It's going to be tough. There are some things in our favor, okay? We have, I think, 5 teenagers. We have 13 cops there, because Garrow is 12 cops in one. But we are outnumbered. They are close. Some of them are close to the bed. They were lying. Well, they were lying after the fact. We learned that they were lying about the weed after the fact, but the cops did smell the weed. Some were in handcuffs, some were not. I believe that if this went to, if this was a public defender who's a typical defender who's overworked and underpaid, maybe they lose their case and the gun comes in. But I think that if you had a good attorney, privately paid attorney that really studies their search and seizure and knows their cases, I think there's a decent chance. I'm not saying one way or the other. I think there's a decent chance that the gun get tossed. But wait, there's others. What about, okay, let's say we have a gray area on the guns under the bed, but what about the weed was found in the toilet bowl tank? Are we good on that? Yeah, I agree. I think we lose the weed. I think we lose the weed. Not if we're trying to get that weed under a protective sweep, you're going to have to articulate that they had access, reasonable access to it. Looking in the tank, we're not looking for people, we're looking for guns. We did see somebody go in there and come out, but I don't think they have reasonable access to it. I could be wrong, but I'm just telling you what I'm seeing from this video. Now, at the end of the day, it's not even going to matter. In most states, the evidence will still be used against them. Why? Most of the kids in there. Why? I I'm pretty sure I have some attorneys. No, the rules are the same. It'll be settled. Exactly, Brian. It's going to be, they're just going to settle. But what is the constitutional principle that's going to come in and affect the outcome of this case? Miranda's a factor, but we're not going to talk about that. The kids, I don't know if okay, you're saying that they're going to throw out the guns because they're kids. Certainly that's going to be a factor. That's why that weed is certainly, I don't think, coming in, because they're going to feel that they're going to want to get rid of the weed. Lawfully present. So that's kind of where I'm going with this, is that the kids, most of those kids, unless they're related, are probably just guests of one of the kids. You know, let's say that a mom rented the room for her son, and then he invited his friends over. Do those other friends have standing? Do they have a legitimate expectation of privacy under the Fourth Amendment in that room? That's correct. That's correct. Therefore, we are going to go through this discussion, right? And we're going to try to battle out in the court. And the defense attorney is going to try to save his client from a gun charge. And at the end of the day, it might have been completely worthless because they don't likely have standing in most states. But I do have officers on this from New Jersey and Oregon, Washington, and so forth. In those states, they would have standing because they are lawfully present. They use a different rule in those states. It's called automatic standing. But most likely in those very tough states, by the way, for courts, I know I have an officer here from at least a few from Oregon, and you work in the toughest state in the union constitutionally. Your state does everything they can to prevent you from doing your job, and it's not right. All right.
When it comes to legal training, we're the gold standard. Visit bluetogold.com or call 888-579-7796 today to purchase the Search and Seizure Survival Guide, register for a class, or learn how to bring our search and seizure training to your agency.